when making awards or enterprise agreements, even by consent, the Commission is statutorily obliged to consider certain things. Now, admittedly, it's not necessarily easy. What Commissioner Muir and I hope to do this afternoon is to provide a bit of a roadmap to the somewhat arcane provisions, it must be said, that need to be complied with before the Commission will approve an award or an enterprise agreement by consent. It is somewhat of a boring topic, let's face it. So we're going to do our best to try and spice it up a little. And in order to try and do that, we're effectively going to interview one another. I'll ask questions of Commissioner Muir about consent awards, and he'll ask questions of me about enterprise agreements. We'll probably add our own 2 cents worth in as well, so we're not completely going to stick to the script. But nevertheless, we'll do our best to inform you on both topics. And at the end of each section, we'll ask questions both of the people here in the room and also those that are online. If you're online, you'll need to submit your questions via the chat feature, and our assistant here is going to pass on any of those questions to us. So, Commissioner Muir, it may seem a bit basic, but what is an award?
That's a good question. An award, we should recall, is a legal instrument. It operates with the force of legislation. It sets terms and conditions of employment. There's a dictionary definition in the Act, which I commend that you read. It's actually even broader than the definition might seem, because it says that it includes any order of the Commission which sets conditions of employment. So even if you didn't set out to make an award, you might have made one. Since 2005, the Commission has only been able to make awards covering the New South public sector and local government employees. There are Section 406(1) says the conditions of employment set by industrial instruments are the minimum entitlement of employers, although most New South Wales awards are now paid rates awards.
And when you say, because I think on the slide at least, that the awards operate essentially by force of legislation, what does that actually mean?
It means that the terms of the award can be enforced through the provisions of the Industrial Relations Act. So obviously it's beyond the scope of tonight's presentation to discuss the enforcement of awards, but it's worth remembering the Industrial Court can order civil penalties for contravention of an award. I'm going to digress and say that I want to remind people that they can make small claims if they bring an industrial dispute, and perhaps that might be an avenue that could be explored by some people. But as I said, I digress. It's important when drafting clauses in awards that they're drafted in a way that is legally precise and with no ambiguity. I can't believe I said that about an industrial award. Most of the disputes that we see are because award clauses have not been drafted with precision and without ambiguity. And whilst, again, this is slightly off topic, it's worth remembering that you might think that everyone knows what the clause means, but if you ask someone outside the room, if they can read it and tell you what it means, that might tell you whether it actually says what you think it says, and that might actually be helpful to everyone involved. As my notes continue, awards should also be readable and easy to navigate so that employees and others can readily understand the rights and obligations contained with them. Again, jargon doesn't help. The New South Wales Public Sector Industrial Relations has published a drafting guide which is available on the internet. It contains some very helpful guidance to ensure that awards are drafted in a way that's legally precise and easy to follow, and structured in a way so that you will capture most of the things that you would expect to capture in an award. There's a list here on the screen. Some of them are mandatory requirements, the persons who are bound by the award, that covers both parties and coverage, area incidence and duration, so when the award commences and how long the award is to last, Hours of work, so Section 22 provides a maximum ordinary hours of employment. Sick leave, Section 26 of the Act provides for minimum entitlements to sick leave. Other clauses that are required include a consultation clause, a grievance and dispute resolution clause. Those two often form part of a single process. Again, they can be overly complicated, and perhaps they can be simplified. If I could ask people to have a think about that. Again, slightly beyond the topic, but I couldn't help myself there. And anti-discrimination provisions required by sections 23 and section 179.
All right, so you've now been allocated a consent application for the making of an award. What's your first step, Commissioner Muir, when you are allocated that matter?
I'm glad you asked that question, because I actually literally do the same thing every time. I go to my computer and I pull up the Industrial Relations Act and I go to the bit that says award and I print on that, I think it's the division, and the New South Wales legislation website produces just that part of the Act, and I hit print. And I take my red pen and I literally sit down and say circle the sections that are necessary for the approval of an award, and check that they are actually addressed in the award. And usually they are, but they are in relation to the content of the award usually, but sometimes not in relation to the parts that accompany the application that describe that are not always as clear as they might be. Then I get out the Industrial Relations Commission rules. There's a practice note 6, and there's the award-making principles. So, unfortunately, that's where we perhaps haven't made it as simple for you as we could, and some of them are repetitive. But if you go through each of them, if you've covered them off for one of them, you'll know when it comes up next that you actually have addressed that. Be aware that the Act and the rules are binding. The principles are a good guide. They can be departed from, but you'll need to explain why they should be departed from. So, in short, I make like a lawyer and I check the mandatory requirements.
And can you just explain to us where we find the award-making principles?
On the screen as we speak. The first decision, number 3, explains the full bench's thinking behind the principles, and the second decision sets out the principles. Pursuant to the award-making principle 3.1 bracket 6, an application for a new award or variation to an existing award, where it's consented and provided the application otherwise complies with the requirements of the Act, the award can be made without needing to go through the various kinds of arbitrated cases which are set out under Principle 9. And while the Commission will, of course, place great weight on the fact that an application is made by consent, there are nonetheless requirements on the Commission which the Commission must have regard to. There are various sections in the Act that says the Commission must, and so the fact that the parties say this is all complied with is not probably just quite enough for us to say yes, it's very good. We're not here to prevent an award being made, but we do have to go through the steps in the Act, and it's never going to be a good submission to say, oh, but last year we got approval on this basis.
And surely, though, some of the requirements that are in the Act, the rules, the award-making principles, they must be straightforward, yes?
Some of them are pretty straightforward. The award must be in writing. I don't know how else you would have had an award, but the Act actually says that an award must be in writing. Only specified parties can be party to an award, and they're the parties who can apply to make an award. There's a maximum term of the award. Some of them are pretty straightforward, yes.
All right. But do you see issues with compliance with the requirements?
Thankfully we don't see issues with those, but the Act actually says these are the parties, and so with my little red pen I'm checking, is this person a party who can make an application to the award? Yes, great, next step. Sometimes there's a lack of clarity in an application about how long the award is to be for. That's important. It's a maximum of 3 years. The award needs to state that.
All right. And I think you've already mentioned that the award is ultimately an instrument of the Commission. So
It's a point of nuance to some extent, perhaps, that an award is an instrument of the Commission. It's not an instrument legally that's between the parties. If you want an agreement that's completely between the parties, the Industrial Relations Act provides for that. It's an enterprise agreement. If you're making an award, yes, the Commission will be guided by what the parties have asked for, but it's still an instrument of the Commission, and the Commission needs to be satisfied. That becomes difficult. I don't know if everyone else noticed, but I'm sure that Mr Robertson and Mr Nassif noticed that the slide that was causing frustration to Commissioner McDonald had the local government award in it. That's a very long award with a great deal of complicated and lengthy provisions. Clearly they get built up over time, but as each new provision comes in, so perhaps some more attention is paid to that rather than to the existing provisions. But again, it's an instrument of the Commission, and the Commission should have some basis to be satisfied that the award is setting, as Section 10 says, fair and reasonable conditions.
yes, so well, let's go to Section 10 perhaps. I mean, in terms of the requirements of the Act that the Commission needs to consider, can you give us an example of it and the process that the Commission might go through when working out whether the requirement's been met?
This is probably the most fundamental requirement. It is the most fundamental requirement. It's not a procedural requirement, it's a question of fairness. If the parties have agreed something, then the Commission will be minded that it is a fair and reasonable condition. But other provisions provide some colour to this in the sense that, and we'll come back to them later, the equal remuneration provisions, the fact that the parties have agreed something doesn't mean that the Commission should uncritically, without some evidence, say that it does actually provide equal remuneration for men and women doing work, the same work or work of equal value. But Section 10 is the most fundamental of those. Look, over the short term, it would be reasonable to conclude that an equal percentage increase to all wages and salary-related allowances would be fair and reasonable. The longer that they've been in place, the more the Commission would be minded to question whether they still set a proper structure. And fundamentally, it's because that's what the Act says. I think I've said that already.
All right, so what are some of the more complex requirements in applying for an award?
The most complex ones are the ones that often there's a question about whether there's a proper evidentiary basis before the Commission for the making. That there's two interconnected requirements. One is the interconnected equal remuneration and anti-discrimination principles, and the other is the public interest assessment.
And are these the ones that show up as the ones that applicants have the most difficulty in addressing?
Yeah, absolutely. That's why Rule 6.8 and Practice Note 6 requires that an application for consent application must be supported by an affidavit which sets out, firstly, the way in which the consent award provides for equal remuneration and other conditions of employment for men and women doing work of equal value or comparable value, and the reasons why the making of the award is in the public interest. It's not necessary to conduct a complete analysis of the workforce in order to meet the requirement, for example, of the equal remuneration requirements, but something should be said about those.
Well, in fact, sorry to jump in, but you've mentioned the equal remuneration principle, and also that ties in with the requirement to comply with the anti-discrimination principles in the Anti-Discrimination Act. Can you walk us through more the issues associated with complying with that requirement?
The barest assertion that an award complies with the equal remuneration principle doesn't say anything about how it does so. It doesn't say anything about the thought process of the parties about whether the requirement for equal remuneration and other conditions for men and women doing work of equal or comparable value. It, as I said, isn't necessary to conduct a complete analysis of the workforce, but if the union official representing the parties or the HR manager for the organisation could say from their experience that they've read the conditions, they've considered the workforce, that they've looked at the spread of gender across the workforce, and that there's nothing in that that would suggest that there's a disparity, that the wages are literally on their face the same for men and women, they don't discriminate, then that begins to become an evidentiary basis on which the Commission can be satisfied that this is complied with. It might be appropriate in certain cases to say that we've considered that most of the junior staff in this particular area, it's a strong preponderance of women in that area and a strong preponderance of men in some of the more senior areas. And we've thought about the difference in wages across the structure and how that's happening, how the progression across the workforce is dealt with in terms of the wages, and that, yes, as you get more senior, you get paid more, but it's not disproportionate to the wage increase as you go through. That there's not a particular area, there's no area where in a workforce that's mostly men, there's 50 women here and they're doing work that's very different from everybody else, but we've thought about the fact that the work value is related to one of the other areas. Say something about that. Or it may be in some workplaces that there's really no gender mismatch between the different areas, and you don't need to address it in any more detail than that. It's likely that it'll be an HR professional giving that advice, giving that evidence, and it's likely to be opinion evidence, but it's informed by the fact that you've been doing that work for so long and you're familiar with the workforce.
And what about the public interest? How does that come into things?
Well, as Commissioner McDonald, you were pointing out to me earlier, it's actually not just in relation to awards, it's in relation to everything that the Commission does. We're required to take into account the public interest. And so some of these issues, I should start with the objects of the Act, obviously. There's the economy of New South Wales and their likely effect on the decisions on the economy, and for public sector employees, there's the fiscal position and outlook of the government and the likely effect of the exercise of the function, which means making the award, on the position and outlook of the government. Again, it's important that there's some evidence before the Commission about each of those matters. It might be that some of them aren't particularly relevant in certain cases, and again, not to pick on the local government delegation here, but the fiscal position of the government isn't relevant in your case. I'd say the same thing as I said about the earlier one, is it not to simply have an affidavit stating it as a concluded fact, that it does not, clearly any decision of the Commission is going to impact the economy to some extent. It's going to impact the fiscal position of the government. Doesn't necessarily mean it's an impediment. It might be as simple in some cases as saying it's in the budget, not to misquote a former federal minister, where it was a surprise. In this case, it's not a surprise, and that we know that it's not going to drastically affect the state of the budget and the fiscal position because it's in the budget papers at that rate.
All right, now I'm going to take you back a step, and we're going to drill a little more into each of those things, the object of the Act, the economy and the fiscal position. So in terms of looking first at the objects of the Act, what will the Commission have regard to when considering a consent award application and the objects of the Act? Which objects of the Act are we really talking about?
Well, it's set out in Award Making Principle 2, which you can see in the state wage case number 4, which was referenced earlier. If you go to the Commission's website and look for the state wage cases, it's number 4. There are five objects which are relevant to the making of an award. They're the promotion of productivity and efficiency, the promotion of participation in industrial relations by employees and employers at an enterprise or workplace level, the prevention and elimination of discrimination in the workplace, in particular equal remuneration, encouragement of cooperative workplace reform and equitable innovation and productive workplace relations, and strategies to attract and retain skilled staff where there are skilled shortages. The affidavit should really set out each of those and say a sentence or two about why the award supports each of those objects. Now, it might be that in a particular case there's an object that there's nothing to add about it, but I would say if you're at a loss to say something about why a consent award might have a negative impact to some extent on the government's fiscal position, it surely must conversely have a positive impact on strategies, new object 3I, which is strategies to attract and retain staff.
Okay, and so let's look at those other two things. So the economy and the fiscal position of the government. What exactly are we talking about there, and what sort of evidence are we really looking for?
So the first of those, the state of the economy, is probably a bit of a hangover from when the IRC regulated the private sector. But when addressing the state of the economy, the parties should consider whether the award will have much. Some may have none. You know, for example, in a hypothetical world where the economy is healthy and pay increases are affordable, the proposed wage increase could be offset by efficiency savings. It could have a positive impact on the economy in terms of having people have the value of their wages maintained, and therefore they're able to continue supporting their local community. It could have a negative impact in particular cases, but that might be offset by other matters. The public interest is it's inclusive, it's at large, and then specifically the objects, the economy, and the state of the government's budget, in short. So it might be that some of them are negative and some are positive. It's an overall assessment of the public interest.
And the fiscal position and outlook?
There's probably not many people in the state who actually could talk to the state of the budget. If you ask the New South Wales Treasury, I'm sure they'd say there's only about 10 people, but it is what it says. It may be that a cohort of a few hundred people makes no difference to the state of the budget. It may be that some of the larger awards make a substantial impact on the state of the budget. It doesn't necessarily require an analysis of the budget. It may be as simple as saying the budget has been approved by the Parliament and it includes these rates, or the budget that the government handed down had increases over the forward estimates of X, Y and Z, and this is marginally above, but that's offset by other matters. It isn't, I think in consent awards it shouldn't be seen as an impediment to approval, but it just needs to be addressed in some way. It's probably not satisfactory to say that I believe other people have assessed it, and the reason it's not satisfactory is that the Commission has to make the assessment of the public interest. It's not an attempt by the Commission to say we need someone from Treasury to come along and tell us what happened at the Expenditure Review Committee of Cabinet. Clearly that's not going to happen and that's not what's intended, but it just needs to be addressed in a way that provides evidence for the Commission member addressing the award to be able to say, I have, this is in the budget, this has little impact on the budget, or some other matter. And in that respect, if the offer is in line or largely in line with an existing wages policy, then that may be all that it's needed.
Done?
I'm done.
Okay. Is there anything else the parties need to be aware of when filing their documents for a consent award?
If there's a no extra claims clause, it's appropriate to alert the Commission to the terms of that commitment in the affidavit. I don't think there's much more to say about that one. I'll move on to the next one. If there's, in the absence of an agreement between the parties, if the obligation's on the applicant to file the evidence, but it might be that some other party is in possession of the evidence or something which would be supportive, there's no reason why the supporting evidence has to be provided by the applicant. And moving on to the next slide very quickly.
Just to address that slide perhaps in more detail, that section there. Think about who's making the affidavit.
I have to say that I should make the confession that the slides were largely the work of Commissioner McDonald, and I found her to be a very, very satisfactory research assistant in this matter.
About the opinion evidence, I make sure.
Yes, okay. Sorry, I understand the point. Look, again, it may be opinion evidence, but someone just needs to explain. We don't need it to be done to the code of expert evidence in the industrial court. In the Commission, we'll be satisfied with someone saying that I've been an industrial officer for 25 years and worked in this area and understand this, or I've been an industrial relations manager in this area and this is my experience for this. It's almost certainly those two sentences by themselves are enough to justify the expertise.
Lovely. And the next one?
My favourite one is where we get to say you have to file an electronic copy of what you want made because we won't be doing that for you. And now I get to return the favour.
Yes, you do. But before
we do that,
well, there's two
excitedly
things.
say that.
There's two things. One is the users and those that are potentially filing applications for consent awards will be pleased to know that we have almost finalised a pro forma affidavit that will hopefully assist the parties prepare the necessary evidence. It's not intent, and there's also going to be a little guide attached to that pro forma affidavit. That affidavit is not in any way, it doesn't supplant the Act, of course, it doesn't supplant the rules, it doesn't supplant the principles. But nevertheless, it hopefully will provide the parties with some guidance and making sure that you tick those boxes and at least turn your mind to some of the things that Commissioner Muir has been addressing. So hopefully will be published very shortly and put available on our website. And so hopefully that will eliminate some of my frustrations and those of my colleagues. But before Commissioner Muir asked me...
Well, I was going to say about those, what it will do is set out the fill in the blanks. It won't necessarily give you the information, but it's a prompt that these are the things to address. And it starts with, I can attest that it satisfies the equal remuneration requirement, for example, because the award does blah. And the blah is the bit you'll have to fill in, but it will remind you that that's what you need to do.
Yes, thank you. Now, are there any questions either from about the consent award requirements from anyone in the room or anyone online? No? Oh, yeah, yes.
Those complaints, would you need to look at the other, there might be other agreements, type agreements that might be carried through? Can you just talk about that?
I think all we were saying there is if you alert the Commission to it in making the application, largely so that it can be understood what is it, no extra claims will be made about it, and in particular if there are any exceptions to that or issues which the parties have agreed can be the subject of further application.
Is that what you were getting at? Yep. Okay. Yes. Commissioner, sorry, Judge.
With the state wage case, I think the full bench also deprecated forms of no extra claims clauses which prohibited parties from approaching the Commission such that making claims might be in contravention of the clause, in contravention of the award itself and attract a single penalty. So the full bench made it clear, I think, that the form of a no extra claims clause should generally take the form of an undertaking. That parties will not make claims during the life of the award that will have effect during the term of the award, rather than a prohibition against approaching the Commission at all.
Yeah, Yes, thank you. That's a very good point, actually. It really shouldn't form a term that can then be prosecuted for a civil penalty. It really ought to just be an undertaking given by the parties that they won't pursue it. And that is typically then one obtained in the course of negotiation to obtain a consent award. Is there any other questions? Georgia, do we have any online? No? Any more here? No? All right, well, fire away. Oh. I'll just repeat the question so that those online can understand that. So the President's just asked Commissioner Muir, if we consider we don't have the materials that we should have to approve the consent award, what do we do?
So, with some experience with applications that I thought didn't quite hit the mark, rather than listing it, having everyone come in and explain it, now what I will do is read the documents. If I think there's a gap, I'll list the matter for a telephone direction to explain to the parties what the gap is, so that people don't have to come all the way to Parramatta for me to say there's a missing piece in your application. So I think that's again an example, and the reason the President's asked it is because it's about an approach that we're not here to stop you getting an award made. We're here just to make sure that we've been tasked with ticking certain boxes, and we are going to make sure that the boxes are complete before we tick them.
All right, where you go?
Well, let me return the favour. With the almost identical question, what is an enterprise agreement?
All right, so in the broad, it's a legally binding agreement that's approved by a tribunal, obviously in our case by the Commission, but it obviously the Fair Work Commission is another place where enterprise agreements are made and approved. And that agreement sets employment conditions for a group of workers, and that agreement overrides any award that might otherwise apply. They are, or at least have been, very prevalent in the federal sphere, but as the Commission's jurisdiction is now limited to public sector agencies and local councils, and generally speaking, the employers and the employees in those sectors are usually happy with the terms set in the awards, which would otherwise apply, noting, of course, that, as was already observed, our awards are predominantly paid rates awards. So they're still setting a floor, there's still a minimum that you have to pay, but they are basically exactly what's being paid, rather than in the federal space where they act as a floor and then people typically will be paid above those award rates. Now, so really since 2005, when the jurisdiction of this commission was limited, the use of enterprise agreements is significantly less than it used to be. That said, there are still enterprise agreements that the Commission approves, and they're typically for unique workplaces within the public sector or for particular local governments and local councils. For instance, the New South Wales Institute of Sport, the New South Wales National Parks and Wildlife Service flight operations, the Sydney Opera House, all of these operate under enterprise agreements, essentially because the manner of work and the type of employee differs from what is typically found in the government agencies more generally. I can see Ross Nassif here from local government New South Wales, and they have a number of enterprise agreements. So perhaps, Ross, I might ask you, why do you use them? Yeah, so just to repeat that for those who are online, essentially Mr Nassif was saying, yes, pretty much what I was saying, that there are unique situations within councils. For instance, there might be indoor and outdoor workers, and there's a preference to then have a different set of conditions for that cohort of workers. There might be particular unique working arrangements or conditions that they would prefer to implement on a smaller basis rather than an entire local government, because as the local government award got mentioned before, it's a very comprehensive award that obviously applies across the whole of local government in New South Wales, but obviously each individual council might have their own particular circumstances. And so to deal with that, rather than have sort of splinter awards and different awards, they do that too, but it's most effectively dealt with by having an enterprise agreement.
So how are they different from awards?
So EAs are similar but different to awards. It's important to remember an enterprise agreement fundamentally is an agreement. Now, that might sound a bit obvious, but what it means is the usual rules and principles that apply to any agreement apply to an enterprise agreement, but with statutory force. So if parties to an enterprise agreement bear this steadily in mind when they're negotiating enterprise agreements and when seeking the Commission's approval of it, it's much more likely that all the necessary steps will be taken to ensure a smooth approval and that process will be straightforward. As we've discussed, Section 12 of the Industrial Relations Act provides that an award will be binding on all employees and all employers to which it relates, whether or not they were a party to the making of the award. Enterprise agreements, on the other hand, are only binding on the parties to the agreement, although they will also bind each employee for whom the agreement is made, because often an agreement will be made with the union on behalf of a group of employees, and it will bind those employees, and it will bind them whether or not they were an employee at the time the agreement was made, provided it's been approved by the Commission, and you'll find that in Section 32 of the Act. Attention then needs to be brought to bear to who the parties to the agreement actually are. Funnily enough, this is one of the hiccups that people can have. They just sort of roll over these enterprise agreements without actually clearly identifying who the parties to it actually are. Now, Section 31 of the Act stipulates who the parties to an enterprise agreement can be, and I'll come back to that in a moment if I can. Like all agreements, as I said, they need to really comply with the usual rules, essentially, that apply to contracts. So they need to be made without coercion or duress and with all the parties to the agreement understanding its terms. And so what the Act does is sets up a structure for that to ensure that that is the case. Essentially, the Act enshrines some common law and equitable principles that apply to normal contracts to ensure fairness. So, for instance, before approval of an enterprise agreement, the Commission must be satisfied that the parties understand the effect of the agreement and that they did not enter into the agreement under duress. It's also important to bear in mind, pursuant to Section 41 of the Act, that the provisions of an enterprise agreement prevail over the provisions of any state award of the Commission that deals with the same matters insofar as the provisions of the state award apply to a person bound by, or would otherwise apply to the person bound by the agreement. So given this, the Act also provides that the Commission must be satisfied that the enterprise agreement does not, on balance, provide a net detriment to the employees when compared with the aggregate package of conditions of employment under a state or, in fact, under a federal award, if that's applicable to the group of employees. So you need to bear those two things in mind. It needs to be fair. The parties need to understand it. There needs to be proper communication, no coercion and duress. And because it is going to override these awards, which are the floor to what should be offered, you need to make sure that what's essentially being offered is at least as good, in fact, hopefully better, usually better, because that's typically why often these agreements will one of the motivations for making them. But it's certainly something you need to bear in mind. Also, if I can just return to the issue of the parties, who are the parties? So Section 30 of the Act provides some limit on the groups of employees that may be covered by an EA. I won't dwell on that provision as it's typically met in the EAs that we see. It's not really an issue. But parties should be aware of it and check out Section 30. Indeed, you should really check out the whole section that deals with enterprise agreements in the Act. But Section 31 sets out who may be parties to the enterprise agreement, and the slide on the screen simplifies essentially what Section 31 says. In short, enterprise agreements can be made by an employer with an industrial organisation, so a union, representing the employees for whom the enterprise agreement is made, or it can be made by the employer and the employees directly. But as the slide shows, if it is being made with the employees directly without the involvement of a union, then there are additional requirements under the Act that have to be followed, including in particular that the agreement needs to be approved by at least 65% of the employees in a secret ballot, and we'll perhaps talk about that in a minute.
All right, so if we get into the nitty-gritty of what needs to be filed to get an EA approved, and are you seeing that all of those details are in the applications that you're receiving and assessing?
As the slide suggests, no, alas no. Now this was recently highlighted by the President in a decision that I'm going to talk a bit about, and the citation for it will follow in a subsequent slide. But in State Super Enterprise 2024 to Enterprise Agreement 2024 to 2025, the President had this to say. At paragraph 3, he said, "It is surprisingly common for the material filed with an application for an approval of an enterprise agreement to fail to establish one or more of the necessary requirements as occurred in this case. Even if the defect can be cured, this slows down the approval process and adds to costs." And he went on to say at 81 and 82, "The application in this matter suffered from some certain basic defects. A review of recent authorities suggests it's not uncommon for applications for approval of enterprise agreements to require rectification. This slows down the approval process and adds to costs." And in New South Wales Institute of Sport Enterprise Agreement 2023 to 2024, Commissioner McDonald at 30 reiterated the importance of complying with the prerequisites for the approval of the enterprise agreements, stating parties seeking approval of an enterprise agreement must pay due regard to the various requirements for approval prior to filing an application in order that the Commission may attend to its task with alacrity. So that's really, I guess, why we're here tonight and what we're trying to address. What I will say, though, two things. One is, as is demonstrated by the President's approach in State Super, there was a couple of significant defects in that matter, and the President essentially bent over backwards to get it over the line. And that is what we will try and do. The other thing that the President did, which is just simply wonderful and fortunate for everyone concerned, including the members of the Commission, is that at the end of that decision, and so that's why I'm going to commend it to you and put it up on the screen in a minute, is he published a detailed checklist of the steps required to obtain the enterprise agreement.
This is the downside of having your very competent researcher do the questions, is that she found a quote where the President quoted her. Well done. Can you take us through the checklist and perhaps highlight those areas that have proven to be particularly troublesome? But can we start with the basics? Where do the parties find the various rules that govern the making of an enterprise agreement?
Okay, so this is very similar to the same structure as the award structure. They're just slightly different. Well, they're different parts of the Act and different rules. So the Industrial Relations Act, of course, is your starting point. It's Chapter 2, Part 2, which deals with enterprise agreements. You need to look in particular at Rule 6.9, which sets out that you need to file an affidavit in support of your application and what that affidavit needs to provide. And then, just as we have award-making principles, we also have principles for the approval of enterprise agreements. And that the last decision for that, and I'll deal with this again in a moment, was back in 2022. I'll give you the citation for it in a minute. But those principles, which are made pursuant to Section 33 of the Act, list a number of things that the Commission must have regard to when considering an enterprise agreement. And essentially those things, again, are really just designed to ensure fairness in the agreement, and as to the process and the outcome of the agreement. Now, it must be said that there is a reasonable, perhaps regrettable amount of repetition between each of these three instruments, if you like. And what's so wonderful about the President's checklist, and my boss is sitting in the back, so I'm going to keep saying this, but what is so wonderful about the checklist is that it goes through the process of negotiating an EA right the way through to approval of it, in chronological sequence, identifying all the relevant sections, rules and principles applicable to each stage. Because frankly, if you try and sort of do that yourself, it's actually quite difficult, I know because I've done it, is that the Act itself does swap around. There's things that are early on in the part that is a requirement that you need to ensure, in fact, later in the process, and vice versa. So it actually is a very useful checklist because it identifies where it lists this is what you need to do. It also lists whether it's a section, a rule, or a principle that is trying to be achieved at that point. Now, so the requirements those things give us in a nutshell are these. The Commission will approve an enterprise agreement. For the Commission to approve an enterprise agreement, it needs to satisfy itself that the requirements of Section 35 have been met, principally that the agreement does not, on balance, provide a net detriment to the employees when compared with the aggregate package of conditions under a state award. The agreement must be consistent with the principles for approval of enterprise agreements, which have been set by the full bench under Section 33, unless the Commission is satisfied that any departure from those principles would not prejudice the interests of any of the parties to the agreement. The full bench last reviewed, as I said, those principles in 2022, and you'll get the citation in a minute, but it's Annexure A. The principles are Annexure A to the decision. And in circumstances where the employees, rather than a union, are the parties to the agreement, then there are these special requirements that I alluded to earlier in Section 36. They must be met, and they include the conduct of a secret ballot, which is provided for in Section 37 of the Act.
And the secret detail you've been withholding, the citation of the...
Yes, so the principles, so the review of the principles for approval of the enterprise agreements is found in the case that's on the screen there. So for those that are maybe listening in the car, the citation, neutral citation is 2022 NSWIR Com 1005, and you'll find them at Annexure A.
And the checklist, where should people go to find that?
Okay, so that's the decision of State Super Enterprise Agreement 2004 to 2007, 2024 NSWIR Com 8.
We might speak to our new interwebs people and see if we can put that somewhere other than in the decision, maybe on the website. And could you give us a bit of an overview of the checklist and perhaps highlight some of the requirements set out in that checklist that have been the source of the most difficulties in your quest to approve the enterprise agreements?
Sure. So the first thing to comment on is that the process of getting an EA approved starts well before an application for approval is filed. The EA itself needs to meet the requirements of the Act and principles, and the process by which it is made also needs to meet the requirements of the Act and the principles. So it's a bit of a journey that starts well before any documents really are being prepared. So the process, well, the checklist prepared by the President in the State Super decision helpfully breaks the process down into stages, okay? And the first stage that's identified is actually before the negotiations for the enterprise agreement starts. So as I've already mentioned, if the EA is made directly by the employer with the employees rather than a union, there are additional steps. And one of those steps is before or at the time of commencing formal negotiations with the employees, the employer must advise the industrial registrar in writing using Form 15, notification of proposed enterprise agreement, that an enterprise agreement is proposed or under negotiation, and the award or enterprise agreements that currently apply to those employees. Now, what that does is it enables the industrial registrar to advise essentially union parties that may have an interest in this. Okay, so they will get notification in case they want to have a say about the proposed enterprise agreement, and you can find that the requirement for the industrial registrar to advise those parties is found in the Industrial Relations General Regulations 2020, Regulation 4. The next stage is the negotiation stage, or the negotiation process. The principles require numerous things to occur during the negotiation process, all of which are designed to ensure that the employees are fully informed and consulted. So I'll just read very quickly through that checklist without getting too bogged down in it, and you'll see exactly why really a kind of a checklist is needed. So the parties must carry out a negotiation process that involves all the parties and their representatives. That's sub-principle 2.1a. Consultative processes are to be structured to encourage participation of all groups and categories of employees, principle 4.1, with reasonable steps taken to consult all employees who are covered by the agreement, or to be covered by the agreement, sub-principle 4.2a. Parties are to attend meetings, provide agreed documentation and comply with reasonable negotiating procedures, principle 5. Employees are to be given access to the proposed agreement and the relevant awards and reasonable time to seek independent advice, sub-principles 4.2d and e. Employees are to be informed of the intention to have the agreement approved by the Commission and the consequences of the Commission's approval, sub-principle 4.2c. Employees and any relevant union are to be given information that allows them to understand the nature and effect of the agreement, section 35(1)(c) and sub-principle 2.1b. Pausing there, of course, every time it is something that the Act requires, it must be done. The principles, not so much, as long as there's no ultimately no prejudice to the parties. And nothing is to occur that would coerce employees to enter into the agreement. That's section 31(1)(d) and sub-principle 2.1c. The next stage, that's your negotiating stage. Takeaway is make sure that everyone's involved in the consultation, they're fully informed of the agreement. That's really the most important aspect of all of that. The next stage is finalising the text of the enterprise agreement to ensure it meets all the requirements of the Act. It's vitally important that parties ensure that the terms of the enterprise agreement comply with the Act and the principles. So there's a long list of those things. I might just, because everyone is able to go to the checklist and go through them all, and I'm sure you'll glaze over if I start going through all of them. I'll just note a couple of them which potentially cause some issues. The agreement is to identify the parties to the agreement and describe the employees for whom it's made. As I think I alluded to a little while back, it's surprising how often that doesn't happen. And so you're not actually, I certainly have had one since I've been at the Commission where it was not clearly identified in the agreement who the parties to the agreement are. So that is one. Another one, the main place to look for these requirements are in section 35 of the Act, but as the checklist makes plain, they're not the only, that's not the only place you'll find them. They're also in the principles. It's to have a nominal term, and that term is not to be more than 3 years, so very similar to awards. And the agreement is to contain procedures for dispute resolution, very similar again to awards. So there's a certain amount of mirroring. What's in an award will also need to be in the enterprise agreement. Now the biggie is the no net detriment test. What the Commission needs to be satisfied is that the agreement is to provide no net detriment to the employees when compared to the aggregate package of conditions of employment under relevant awards. And if there is no relevant award, it is not on balance, on balance, provide a net detriment to the employees when compared to the aggregate package of conditions of award under an award that covers employees performing similar work. So if there's not a direct award that applies, you need to try and find one that's a proxy for the work that is being done. Now, if the parties are uncertain as to which award might be appropriate for the purposes of this comparison, the parties may consider applying to the Industrial Registrar pursuant to section 36A subsection 2 for a determination of the relevant award against which the agreement will be compared for the purposes of the application of the no detriment test. Now, please note that the comparison for the purposes of the no detriment test is against an award, a state or a federal award as appropriate, that would otherwise apply to these employees or one that is a proxy for it. It is not against last year's EA. Okay, I've had a number of applications where it said there's no net detriment because these terms were all in last year's agreement. That is not the test. The test is because this agreement will prevail over the award, so we need to make sure that people are actually not worse off than what they would be under the award. I'll return to the no net detriment test again in a moment. In terms of the process, the next stage is after the negotiations, and this stage is really only relevant to those EAs which are not being made with a union, so those that are being made directly with the employees, because a secret ballot needs to be held, and ultimately proof of that ballot provided to the Commission to ensure that the employees agree to the terms of the EA. Now, this is also an area that can cause quite a lot of difficulties. Again, I'm not going to go through all of the requirements for the secret ballot. You can look, it's found in section 37. You can have a look at the checklist. It's really important you do if you're actually arranging an EA directly with employees. One thing I would say is that the returning officer for the ballot needs to be a person other than the employer or a person selected by the employer. I had one, and I'm sure it happens not infrequently, where just the HR person does it. And they're just that's not compliant. It needs to be, usually it's an employee who volunteers to do it. And it certainly can't be someone who is appointed by the employer to do it. So it's not uncommon for that to be breached.
Can I just butt in there? I mean, if you're going to appoint an external, the workaround effectively is if the employer is going to pay for it, give the money to the employees committee and ask them to engage the person to conduct the secret ballot.
Yeah, yeah. Now, the principles set out in some detail how the vote should be conducted in order to ensure it's fair and appropriate. But they do at the moment, of course they were last reviewed in 2022, they do at the moment they presume that the ballot will be conducted by paper, whereas increasingly, of course, it's being done electronically, but using things like survey monkeys, and survey monkey. And so consequently, not all of the principles necessarily fit. Like you need to initial the ballot paper, you need to retain the ballots. In fact, of course, if it's being done by a survey monkey, that doesn't happen. And even the counting process is different because it just spits you out, the result. There is no sort of counting that can be scrutineered in the way that a paper ballot would normally be done. Now, that's probably something the Commission will look at when it next reviews the enterprise agreement principles, which I think is coming up. I'm not sure, something be on the list of the many things that need to be done. But that's certainly something that is on our radar as something that needs to be done. Of course, there's nothing in the Act or the principles that prohibits electronic voting, so it's completely possible to do it that way. But you'll just be aware that some of those principles are not necessarily relevant, and you probably then, in filing your affidavit to say you've complied with all the principles, etc., to explain the process of the electronic voting and why it's not possible to comply with certain of the principles, but no one was prejudiced as a result, and explain that in some depth. It's important. It's not uncommon. One thing that is very important, and this is the situation that the President had to deal with in State Super, and it's also one that I've had to deal with, is that the Act requires the Commission, that the Commission's approval, or the Commission can only approve an enterprise agreement that has actually been voted on. And it's not uncommon that after the vote, some error is discovered in the document, in the enterprise agreement itself, and people will then go, oh, well, that's fine, it's a minor thing, or it's beneficial to the employee, so we won't put it to the vote again. We'll just tell all the employees, we'll send them an email and ask them if anyone's got any concerns, and then away we go, and we'll just file this correct version of the enterprise agreement, even though that's not technically the one that was voted upon. Now, as I said, that was the problem that confronted the President. He overcame it by effectively getting them to amend the application to put the originally voted upon agreement back in, and he approved that, but he also got an undertaking from the employer not to enforce the parts of the agreement which were now wrong, and that he would, making a note. I thought you were winding me up.
No, I might do that too.
So just be aware of that. You can either, obviously enough, take it back to the vote, and that's probably the preferable thing to do if you've noted it, but you will have to deal with it because there is no discretion in the Commission to otherwise approve an agreement that has not been voted upon, okay? It's not a discretionary matter, it's a mandatory matter, so we don't have any wriggle room on that. In state super as well, the President considered that a failure by the returning officer to accurately advise employees of the date and time the votes would be counted, so that employees could scrutinise the count was not prejudicial ultimately to the employees, and so he exercised his discretion to approve the agreement. So that was a matter that simply required in the principles. So he was able to exercise discretion to determine that that wouldn't stand in the way of approving the agreement, but the fact that the agreement was not the one voted on was a far more problematic issue. So the last sort of substantive stage is preparing to file the documents with the Commission. One thing everyone needs to be aware of is that the agreement must be signed. This is, again, this is so often breached that the agreement attached just isn't signed by anyone. Now, you should be aware that the Act in Section 31 actually sets out who can actually sign the agreement when it's made with a group of employees. Not every employee has to sign it. That's actually set out in Principle 3.3. But there's also, if you're doing it with a union, Section 31 tells you who should be the appropriate person signing. So make sure it's signed. The next step is by far the most problematic, and I'm conscious of the time, but I really do need to talk a little bit about this, and that is that the applicant for the award must actually prepare a comparison and compliance statement. It must be filed with the application for the approval in the form of an affidavit. Now, that's in Rule 6.9 of the rules. And it's not sufficient to simply assert there will be no net detriment to the employees. You need to go in some detail a bit about this. Now, a lot of parties will actually engage consultants like Mercer, etc., to do an analysis of the enterprise agreement against the relevant award. So obviously the rates of pay are the key one, but they're not the only one. You'll need to go through and actually analyse things like the overtime payment, the hours of work, those sorts of things, to make sure that the overall aggregate package is not worse than what they would be, what the employees would be on under an award. Any detrimental differences should be clearly identified, along with any explanation as to why, despite such differences, it's contended the agreement will not result in a net detriment to the employees. The statement needs to address all the matters that are listed in Principle 2.5. Again, if you go through the checklist, you'll find more details about the compliance statement, but mainly check Rule 6.9 and the principles. And I really commend to people the decision in State Super and the checklist to better or actually the whole of the decision in State Super, to really understand better what's necessary when doing the comparison evidence. You also need in that affidavit to spell out how you've complied with all of the things you're meant to comply with, which is tedious, which is why we're also developing a pro forma affidavit to hopefully make that all a little simpler. And if there's a need for the secret ballot because you're dealing directly with employees, the person, there'll need to be an affidavit to explain the steps that were taken to say that they've complied with the Act. The application is just a Form 14A, the same as an application for a new award or a variation of award. You just tick the box and say this is one for an enterprise agreement. There are particulars at the back of that form which you fill in the particulars about your agreement, and you file it with the affidavit. And as I say, make sure you need to attach the agreement, it needs to be signed, and please make sure it's the one that was voted on by the employees if it's one with the employees. And so now at last you can file the documents after going through all of that process. Lastly, the President explains this in the State Super decision, but applications for approval will ordinarily be listed for first mention before a registrar for a compliance check. An application for approval of an enterprise agreement being filed to which employees are a party, the registrar is required under section 36(5) of the Act to prepare a report, so effectively another comparison report to make sure that that EA is actually, again, it's really a version of the no net detriment test, but the registrar will do that where there is an employee, direct employee EA. And where that report from the industrial registrar identifies no matters of concern and no person appears at the compliance check to oppose the approval, and where the checklist has been strictly complied with, a member of the Commission may then proceed to deal with the application on the papers. Otherwise, you'll be required to attend probably for directions in the first instance to tell you why you've got it wrong.
Thank you. There are two questions. We've got, I think you can, one of them you'll be able to dispose of quickly. A question about the voting requirements for an enterprise agreement that's made with a union.
There's none. I think I'm right in saying that. There's none. It's only a requirement when you're dealing directly with employees. It's assumed in the Act that if an industrial organisation is the party to the agreement, that they're operating in the best interests of the members that they have coverage of in that workplace.
And the second question, which I'm tempted to say the answer is no because the words are different, but I'll ask it anyway because the question is whether the no net detriment test is the same as the Better Off Overall test in the Fair Work Act.
To be honest, I don't really know, but I think the answer is probably no. I can't confess to being a federal space expert.
I'll have a stab. One says no net detriment, one says better off overall, so they're clearly different. And secondly, ours is clearly simpler and easier to implement than that terrible federal system. Are there any other questions in the room that anyone wants to ask? Yes. So the question is, in summary, that a number of enterprise agreements have been made with the CFMEU, and what impact might a deregistration of the CFMEU have? I suspect it's largely a question for our colleagues at the Fair Work Commission, in the sense that I don't know that we have any enterprise agreements with the CFMEU, but my guess would be that the agreements would still have their force of law. But it's because it's almost certainly a Fair Work Commission question, I probably can't give you a clearer answer than that.
The Commission's been pretty critical of unions recently taking industrial action, quick to give orders against industrial action, particularly where they're seeking an award from the Commission at the same time. In the federal sphere, this is, while you argue for an enterprise agreement, is the most or the only lawful and legitimate time that a union can take industrial action. It's a perfectly legitimate bargaining tactic in that system. What's the Commission's approach to industrial action?
I'm going to deflect the question because it's beyond the scope of the seminar, and B, it's above my pay grade. So I don't know if the President wants to weigh in, but it's a question that's probably addressed if I'm being completely blunt, in the published decisions of the Commission. Mr. President.
Is it the case that we will have on our website some guidance beyond the affidavits and these matters, so that that's something that they can go to, including to watch this seminar?
I believe the seminar, now if that's going to be of use to you or not, I don't know, but it will be available on the website. I think the previous one was. I've made a note to extract the checklist for enterprise agreements from the super decision. I think that can be published separately on the website. In preparing this, Commissioner McDonald and I have been given by other people who's done a great job of researching it, but principally Commissioner McDonald as the principal researcher has re-edited those, and I think with perhaps after a further review internally they might be published, perhaps, I don't know, to the consultative group first for their feedback, but I think that will come on to the website at some point shortly.
That's the pro forma affidavits.
Pro forma affidavits, which yes,
Yeah.
I think that was the intent of the question, or was there?
Yeah.
So for those online, and correctly, I've completely missed the point of the question. There is underway some work to provide a series of shorter videos and online guides that will deal with smaller pieces of this, adding up to perhaps the whole of the seminar and other topics, pitched perhaps at a lower level than most of the people who are watching, pitched ideally so that even self-represented applicants would understand what's happening, but certainly of use to professional industrial advocates as well. I don't know if there's a time limit on that, but I know there's a great deal of work that is going into that at the moment.